Hello, everyone. Welcome to the 2022 Hot Topics in Environmental Law Summer Lecture Series. This is our last week of Hot Topic presentations and our last week of the summer session, and we really appreciate those of you who've joined us throughout the summer. I'm Jenny Rushlow, Interim Graduate School Dean and Associate Dean for Environmental Programs here at Vermont Law Graduate School, and we're very glad to welcome all of you who are here listening today and watching. Each of these talks is worth one Vermont CLE credit, so if you'd like to claim that credit, you'll need to keep track of the talks that you attend for your records. We'll have time for Q&A at the end of the presentation today. Hold your questions. Well, actually, you don't need to hold your questions because if you're watching on YouTube or on Facebook, you can enter your question in the chat or the comment space and we'll get through as many as we can. And you can actually enter those questions at any time during the talk and we'll just aggregate them on our end. Today, we're very pleased to welcome Michael Harris. Professor Harris is the director of the Vermont Law and Graduate School Environmental Advocacy Clinic and an associate professor of law here. He has litigated environmental cases and supervised law students for more than 2 decades. Before joining VLS in 2022, he was General Counsel and Director of the Wildlife Law Program for Friends of Animals, an international nonprofit animal organization. From 2008 to 2014, Professor Harris was an assistant professor of law at the University of Denver Sturm College of Law, where he also directed their environmental law clinic. And he previously worked for Earth Justice, the South Coast Air Quality Management District in Los Angeles, and several private law firms. He's published papers that look at the intersection of environmental and administrative law in multiple law review and journals. And he received his JD from UC Berkeley, a master's from Vermont Law School, and a bachelor's from Pitzer College. Today, his talk is titled, "A Right of Ethical Consideration for All Non-Human Animals, the Capabilities Approach and Beyond." Please join me in welcoming Professor Mike Harris.
Thank you, Dean Rushlow. I really appreciate it, and I'm very happy to be here. I know it's been a fantastic series so far, and I'm happy that this week we get to turn to the subject of animal law, which I believe is a very hot topic and has been in environmental law for the last 15 years. For one thing, we've seen just an explosion of animal law programs at law schools across the country, including an amazing one here at VLS. I should say the Vermont Law and Graduate School. I need to get used to that. One that we got a new permanent director, and we're starting an animal farm clinic. That's sort of been the trend among law schools, and I think it's really exciting that animal law has become such a staple of legal education. It's also, interestingly, become a staple of environmental organizations across the country. In the last few years, we've seen mainstream environmental groups, whether it's the Center for Biological Diversity or the Sierra Club or many of the other ones out there, sort of embrace animal law principles into their work. So I think it does fit really nicely into this series. So I want to start my talk, and hopefully for those of you that are watching, you could see my slide presentation here. I want to start my talk discussing this picture in the upper corner of this title slide. This is an elephant, of course. You can see it's chained to a post. This picture was taken by my wife on a trip that we took in 2010 to the Chitwan National Park in Nepal. If we were to pan out, we would see that there's a lot of other elephants that are in similar situation, chained to posts. This one's also is actually a juvenile. There's a lot of adult elephants here as well. During the day, this is in the evening when this picture was taken, during the day, these elephants perform labor throughout the park. Could be using their trunks to clear brush, move wood, using their backs to bring supplies around the park. Some of the older elephants would have tourists on their backs, and at night they get chained to these posts and fed. So this picture brings a lot of questions to mind. You could see his eyes are closed, or her eyes are closed, resting the trunk on the post. Is this an animal that's just tired? It's the end of the day, time to rest, wait for food? Or is this animal in contemplation? Is it thinking about its plight? Is it thinking about that chain and the role that post has played in its life? There's a lot going on here. And I think these questions, and not just the answers to them, but the contemplation of what this might be occurring in this animal's mind, is what we want to sort of bring to light through a right of ethical consideration. Now, there's a lot of pictures on the internet, thousands and thousands, that raise similar questions about, are animals experiencing emotions? Are they showing happiness and joy? And we see those all the time. And of course, I'm going to show you a few of them to get everyone excited about this topic. So these are the kinds of pictures we're used to seeing about animals, right? And it raises questions. Are these animals engaging in some type of play or sort of showing love to one another? Or are they just getting in each other's, face sort of naturally, just as a matter of like being close together? What is this guy doing? Is he laughing at something in that his peers are doing? Is he egging them on? Or is he getting angry? Is this an embrace of some type of a reunion? Or is this a fight? These are these reflection pictures we see a lot. Is this animal shocked and astonished that that's the way she looks? Or is this some type of reaction to another animal coming into her realm and her ambient? Is this a cat that's feeling emotional love to the petting of her human? Or is their eyes closed because she doesn't know what's next? A dog, is this dog waiting for and feeling lonely in the absence of their people? Or is this just a lack of stimulation in their environment? Is this dog showing joy and playfulness, or is it asleep? Is this bonding, love, connection between a father or a mother and the offspring? Or is it natural closeness for protection and some type of need to be safe? Is this sibling love or sibling rivalry? Is this contemplation or absence of stimulation? These are questions. What are we seeing in these pictures? What are we seeing when we observe animals? Are we seeing emotions? Are we seeing happiness? Are we seeing sadness, loneliness, playfulness? Are we seeing them console one another, showing empathy towards their peers? Is this advanced emotional and social behaviors? Or are we seeing snapshots of animals that are simply behaving as a result of some automated biological response to stimulation in their environment? As Descartes would say, right, and believed, animals are robots. They cannot reason, or he believed couldn't even feel pain. Now, these are important questions. We have asked these questions for 1,000 years. But the answer to them are more important than ever, because what we personally believe we're seeing, and maybe it's just because we think we want to see them, or maybe there's more substance and science behind it, but the answer to these questions will lead us to a selection of our own personal motivation for providing protections or not providing protections for animals, or providing for animal rights. So here's a list of motivators that are commonly seen as the basis for either current and existing animal laws or proposed animal laws. One is human need. This is one of the oldest. For as long as humans have been humans, we have needed animals for food, for clothing, sometimes for protection or companionship. Over the course of centuries, this has led to laws that treat domestic animals as private property. It has led to laws that the sovereign has sort of exclusive rights over wild animals. In more recent times, it has led to the law of capture. That is, how does an individual convert a wild animal to property? So these are very fundamental motivations for legal protections of animals. More recently, we have thought about the need of animals in a role of ecological balance, right? That they are part of a broader ecosystem that also supports us. This is probably the driving force behind the Endangered Species Act, for instance. It's interesting, in the Endangered Species Act, the act itself never uses the word animal, for instance. It speaks only to species and subspecies and populations, excuse me. And it seeks to protect these species as biological units that depend on certain resources within the environment that they need for survival, sufficient resources for food, for habitat, for breeding purposes. It doesn't say anything about these animals' happiness or their sadness. It's all about sort of preserving the ecological balance by preserving these biological species within it. And then we have the motivator of pain and suffering. The debate over animals experiencing pain and suffering goes back centuries. But in the last 100 years or so, it has become much more accepted that it is a fact. And it has been the root of most of what we think of as animal law today. So for instance, state animal welfare laws that prevent the wanton abuse or cruelty of domestic animals is based upon avoiding their pain and suffering. We have state laws that dictate certain humane practices for hunting. We have the Federal Humane Method of Slaughter Act for farmed animals, which, by the way, excludes millions of farm animals that we know experience pain and suffering, chickens, turkeys, and many other animals. We have the Federal Animal Welfare Act, which is the main act for setting minimum conditions for transporting and raising millions of farmed animals and animals that are held in captivity for entertainment purposes as well. Notably, that act excludes the millions of animals that are held in captivity for research purposes. So pain and suffering has become one of the primary motivators for advancing what we would call animal welfare laws over the last century. Recently, we have seen two more motivators come into play: intelligence and self-awareness. Intelligence really dates back to the work of a lot of field biologists and wildlife scientists coming out of the 1960s, 70s, and 80s. People like Dr. Jane Goodell, Franz Delal, and Dr. Joyce Poole, all who clearly, just being so present with apes and elephants and others, realized that there's more than just pain and suffering and biological responses occurring. These animals were displaying intelligence, things that we would think are very akin to our own lives. Out of just this notion of how intelligent some of these animals can be, became testing about self-awareness that occurred with captive animals, the whole mirror test, for instance, the recognition of an animal of herself versus a human captor or another animal or even a peer animal. And both of these together have led to a wealth of legal theories promoting animal rights. What comes to mind, I think, the most is the work of lawyer Stephen Wise and those who have been advocating for personhood. We've seen a number of lawsuits raised in the last decade that seek to establish personhood for chimpanzees. And most recently, there was the Happy the Elephant case in New York that was ultimately rejected by the High Court there, the Court of Appeals, but for which personhood was established primarily on evidence of the chimpanzee or the elephant's level of intelligence, self-awareness. Some might say that sort of the relationship to human traits that we protect by law through the personhood statutes, through habeas corpus, through laws that give rights for preventing captivity, rights for freedom of expression, for freedom of movement, and so forth to humans should also apply to them. So those are motivators that are clearly at play in current animal rights movements. And then closely related, of course, is sort of taking the next step to consciousness or animal sentience, which goes beyond just a level of intelligence and self-awareness. Sentience refers, right, to the ability for animals to actually feel and experience emotions, joy, pleasure, pain, and fear, and not fear as a response, but the type of fear that we would have, where we could actually foresee it and dwell upon it and think about fear even in the absence of the actual stimulation of fear. So sentience is obviously spoken of much more as a motivator for animal rights than it has in the past. It hasn't supplanted, I think, intelligence and self-awareness of some of the current efforts to change the law for certain animals, but they certainly all go together. In fact, in Steve Weiss's most recent litigation over Happy, for the first time, he introduced declarations from philosophers, which we will be talking about today, that raised not just the intelligence and self-awareness factors for personhood, but the ability of animals like Happy to feel emotions. Now, in the US, we haven't seen any new laws that protect animal sentience. We have seen changes in behavior of corporate actors. We've seen, for instance, the dismissal of whales and some dolphins from exhibiting for entertainment purposes by SeaWorld here in the United States, by Marineland up in Canada. We've seen the end of live animal performances at the mainstream circuses. We've seen many zoos based upon the belief that at minimum there's intelligence and self-awareness, but more likely that animals have, like elephants, have emotions. Close down elephant exhibits, for instance. So while the law hasn't necessarily changed, we have seen behaviors change based upon these motivators. Internationally, we have seen some legal precedent set that animals are sentient beings. I think what comes to mind from most recently would be the case of Cecilia, the chimpanzee at the zoo in Argentina, and rulings by courts in that country that Cecilia is a human legal person with inherent rights and is a sentient being. So these motivators are at play, and they're important for us, I think, sort of to adopt as where we feel and what fits into our belief with regard to animals and the rights we want to bestow on them. Now, I want to talk about the right of ethical consideration. Now, I want to just warn you, this first two slides are going to leave you a lot of questions, and I understand. I want to give you a broad overview of the right now, and then lead into a more descriptive discussion of what we mean by a right of ethical consideration in a few minutes. Right now, what I want to just do is to give you an idea of what we're talking about. What we're talking about is developing a legal system that promotes and encourages, if not obligates, a more careful consideration of how human actions, whether they're beneficial to us or not, can produce harm in the day-to-day lives of other non-human animals. And when I mean harm, I am talking not just physical harm, because we've already sort of addressed some of that. I'm talking about emotional, mental, and also social harms to animals. So excuse me here, let me get this next slide here. What a right of ethical consideration is not, is a substantive right. We're not talking about a ban on captivity of an elephant. We're not talking about a prohibition on certain treatment of chimpanzees in research. What we're talking about is a deliberative requirement in nature. I think for those who are more in tune to environmental law, you could probably think about the National Environmental Policy Act, right? In the 1970s, we did adopt a lot of substantive environmental laws, the Clean Water Act, Clean Air Act, the Endangered Species Act. But NEPA was also designed to be a very deliberative attempt to try to bring into question our broader impact on the environment in ways that the substantive law wasn't addressing. And so a right of ethical consideration is akin to that. I think it's also akin to Section 10 of the Endangered Species Act, which requires consultation over the impact of federal projects on endangered and threatened species, deliberation to determine whether those species might be brought into jeopardy. There's also non-environmental statutes that are deliberative in nature. There's consumer protection statutes that require, for instance, disclosure of material risk to investors, or ensuring that consumers have access to all the information in making choices in products or in how they spend their money. So its idea is to produce information that will enhance our ability to understand our impact on the lives of animals. It's also multidisciplined in nature. And what I mean by that is that we want to look at it through a philosophical lens. That philosophical lens helps to present the questions that we need to ask about what it is for a specific animal to live a meaningful life. And I want to highlight here that it is very species by species dependent. We can't have one list of questions or have one set of a list that defines a meaningful life for all animals. What we might believe is a meaningful life for an elephant or a chimpanzee is one thing, but what about what a meaningful life is for a crow or a raccoon or a penguin or a snake? So a philosophical lens helps us frame questions to get to the meaning of a meaningful life for a specific animal, for a specific species. Then we need science to help answer those questions. And then we need the law to disseminate and deliberate on that information. And while we'll talk about it later, I hope you understand that the purpose of that, of course, is to incorporate a broader understanding of human involvement in animals and what we need to do. And I'll say one thing, going back to that list of motivators, I do think we have a clear trend in becoming increasingly aware of not just animals' pain and suffering or animals' intelligence or self-awareness, but also the sentience. And I think a lot of the reason that we have more focus on protecting animals in that way today is because of a broader shared experience over the course of the last few decades. We have more animal rights organizations. We have more organizations focused on the ethics of eating animals. We have more media coverage over the human abuse of animals and impact to animals. We have more coverage of litigation that Steve Wise and others have brought, and Friends of Animals was instrumental in when I was there, about protecting animals, not just simply because they're part of an ecosystem, but because they have meaningful lives. And of course, we have more science than we've ever had about the emotional and mental and social lives of animals. So a right of ethical consideration helps to feed those shared experiences and hopefully contributes even more information and more relevant information that expands the desire and the motivation for increasing animal protections in the future. So let's talk about each of these three components: philosophical, science, and legal in a little bit more detail. So let's start with philosophical. So the philosophical component really helps us with the right of ethical consideration in two ways. First, it helps us provide our basic understanding about our obligations to promote the richness of non-human animal lives, and particularly to protect them from this physical, emotional, and social suffering. And second, hopefully it provides us a scientific framework, scientific questions that we can ask to do so. I want to sort of highlight and give an example of what I mean by these two purposes by looking through the lens of two philosophical sort of perspectives with respect to animal rights: reason and rationality and capabilities. And these are very related. But let's start with reason and rationality. I'm not sure how many of you have heard of a man by the name of William Bartram. He was a Philadelphia Quaker. I did not hear of him until about a decade ago when I started doing animal work. He lived in the late 18th century, early 19th century. He was a philosopher, he was a vegan, and he was a very influential naturalist during his time. He was also, as far as I can see, one of the earliest people to even mention, let alone advocate for what I'm calling today a right of ethical consideration. In fact, he used those terms for non-human animals. Bartram's work really starts and picks up on work by John Locke from a century earlier. So, as many of us know, John Locke made the case that even through just simple observation of animals, we could see that they appear to live a life of reason. And Locke and Bartram would both argue that, even without applying the scientific inquiry that we can do today, that animals appear to behave in purposeful, creative ways and capable of activities that display utility, beauty, and orderliness. In other words, with reason and rationality. Now, Bartram's work goes further than that. So Bartram believes that part of being a rational actor is also having moral awareness. He would offer us the following. He would say, what is ethically appropriate for one rational agent is appropriate for all rational agents. I think he believed that as sort of mega rational actors, humans being sort of the only mega rational actor, we also have a higher moral obligation. And that our obligation includes to the promotion and flourishing of others in our moral community, which in his mind would include all sentient actors, human and non-human alike. Now, I think the real point, though, of Bartram's work is this, is that it's not just enough to look at the activities of animals and assign reason and rationality to them and focus particularly on the utility of what they're doing, but that we should engage in the inquiry about whether those rational motives have other causes, including promoting the animal's own happiness. And in his view, it did. That utility was certainly a function of what animals' daily actions were, but it couldn't explain everything that they were doing. And that it was clear that some of their actions were about their own pleasure and happiness. And if that is the case, Bartram would say that we have the moral obligation to conform our behavior to promote, or at least not inhibit, that animal's well-being in that way. So I think what he's doing is setting us that framework, right, for inquiry into what an animal's behaviors are and what its needs are. And this leads me to the capabilities approach. So this really stems from the work of Professor Martha Nussbaum at the University of Chicago and her own version of capabilities approach. Now, I should just step back and say, for those who are not familiar with the capabilities approach, it is a system that seeks to promote social justice, or at least measure the amount of social justice and human rights in society. The capabilities approach at its heart argues that we shouldn't be measuring social justice and human rights by simply looking at how well a group of humans is doing with regard to average utility. Again, I think that echoes a little bit about what from Bartram's view as well. But we should really be asking whether individuals are doing well in important areas of their lives, how well society is in promoting individuals' well-being. And in her mind, and she calls these capabilities, there are certain things that go beyond just the day-to-day utility in our lives. There are certain things that all humans sort of strive to increase within their lives. These are capabilities in her mind, and Martha has provided a list of 10 capabilities that she believes is shared among human beings and that we need a minimum level of in our lives to ensure our own happiness. And more importantly, within a society, within a group of people like the United States, our laws need to protect and preserve. And otherwise, we're not providing a very decent system of social justice. Her list includes life, bodily health, bodily integrity, sense, imagination, and thought, emotions, practical reason, affiliation, connection to other species, play, and control over one's environment. In her mind, we are striving for these things in our lives. All of us are. And a legal system that doesn't protect our rights to those or promote our ability to engage in those activities or in those securities is failing in protecting our human rights. I think a good example, I think, is what we've seen in Supreme Court last month. And one could argue, and Martha certainly would argue, that by depriving us of women of bodily integrity or control over their own environment, that's a barrier to flourishing and also a demotion in our system of social justice and human rights. Now, turning to animals, Professor Nussbaum has argued that dignity is not just a human right, but it belongs to all animals. In her view, and I'll just quote her, each creature deserves ethical consideration for what it is and kind of a constitution that specifies what harms it should not be permitted to suffer. She says that it is not in terms of its likeness to humans or its possession of some least common denominator property, which, by the way, is her way of saying it's not just about intelligence and self-awareness that some animals share in common with us, but instead it's about what it means to be sentient to them. It is in terms of what it is to be themselves, the form of life that they want to lead or could lead. In other words, going back to what I previously said about the right of ethical consideration, capabilities might be shared among humans, but they may not be shared among species completely. Each species is likely to have their own list of capabilities, their own needs to flourish. Now, there may be overlap. It may very well be that some animals need a sense of play or sense of bodily integrity, maybe many animals. But we can't simply assign the same capabilities that humans have to other animals. She can't provide us a list for every species out there, but what she can do is provide us questions, a scientific framework for evaluating the capabilities and needs, the physical, emotional, and social needs of other animals. So she has proposed, for instance, some of the following. She has proposed to ask questions like, what type of movement from place to place is normal and more pleasurable for an animal? What is it for a particular animal to live that is crippling and intolerable of fear or depression, or with a lack of bonds that animal maybe have concern? What type of affiliations does this animal seek in the wild? What sorts of groups, both reproductive and social, does it form? What is it for this animal to be humiliated and disrespected? What is it for this animal to play and enjoy itself? Does this animal have meaningful relationships with other species in the world of nature? What type of objects does this animal use and need to control if it is to live its life? So she gives us these questions, which brings us to science, scientific imagination. And the real question here is, what can we use science for in order to turn these philosophical arguments for animal rights into proof of the need for legal protections for the emotional, mental, and social lives of animals? Proof of sentience, one may say, but even falling just short of that, proof that we need to conform our behavior better for other non-human animals to live meaningful lives. Now, the good news is the age of science denialism has been declared over. And what do I mean by science denialism with animals? And that is I think in the terms of, in the words of Franz de Waal, right, that science has, for the longest time, has depicted animals as stimulus response machines and have declared their inner lives barren. Professors James Ha and Tracy Companion have put it this way: it wasn't so distant. It wasn't such a distance pass when the idea of animals being capable of feeling emotions was unorthodox at best and blasphemous at worst. But the centuries since those dark ages of animal science, new hypotheses have emerged, suggesting that there's not only ample scientific evidence of emotions in animals that are complex and charismatic, like dolphins, apes, elephants, and dogs, but even among insects who have some of the most simplistic neurological circuitry in existence. In other words, for more than 2 centuries, animal scientists rooted their work in biology. I always use this term biological unit. We always concerned ourselves about what animals needed to survive from a biological standpoint, not from an emotional standpoint. And this gave scientists, veterinarians, wildlife biologists, ecologists, a license to ignore the impact of human activities on that broader quality of an animal's life. This is clearly changing, and I give a lot of credit to an emerging field of compassionate conservationism. It is something that has emerged from all corners of science, but which a lot of credit goes to Professor Mark Bekoff at the University of Colorado, bringing these folks together into a field that proposes a conservation ethic to consider animals as individuals, not just members of a population of species. But the real gift that compassionate conservation gives to us is it takes away that old license and gives us a new license for science to be more imaginative. And what we have seen in the last decade, at least, is just a ton of researchers giving us ample evidence and new data that's constantly coming in on a daily basis, really, to support arguments that many animals, if not all, do live these deeply rich, complex, emotional, and social lives. And more importantly, that license is carrying over to what we might have considered more hard science, like neurobiology, and giving those folks the sort of the incentive and the interest in exploring whether they can map out in the brain the sort of the same type of responses to emotions that we have seen in the brains of humans. And so it's just been a collective change in how we view the science of animals. It's no longer physiology. It's about looking at anecdotes and empirical data and philosophical arguments and even hard evidence in research for animal emotions. It really does put the ideas that Bartham expressed and what Martha Nussbaum is expressing into practice and evolving us into proof. Which leads us to legal ingenuity, the law. Unfortunately, the law is stuck. Really, we remain in an age of legal denialism. The law does not recognize animal protections that go beyond physical pain and suffering as a general rule. I don't know of any immediate offerings. Personhood movements are in court, but they have not gained any traction as of yet. It's amazing to have those cases heard in higher courts. And I do think there will be a breakthrough as there was in Argentina. But right now there is a lack of legal ingenuity. But as I mentioned, there are these informational laws out there. These laws that encourage us to deliberate over issues like this. They don't provide substantive protections, but they can lay a foundation for change. We've seen in the context of environmental law and consumer law that because of the access to this information and legal obligations that they be produced, that would encourage more ethical and reasonable judgments, that they can encourage future changes in substantive law. I think what's important here is that these laws haven't been used necessarily to promote animal rights yet. We haven't seen the use of the National Environmental Policy Act or consumer laws to encourage a consideration and decision-making of how human actions can impact emotional and mental and social lives of animals. And that's what I'm proposing. So the idea is a right of ethical consideration is to utilize existing informational laws to assemble a larger audience for the philosophical and scientific arguments that human actions do and can impact the lives of non-human animals beyond pain and suffering. So I have this little chart here to exhibit a little bit about how this would work. And so we'll use a case that Friends of Animals worked on in 2016 as an example, a case that unfortunately didn't make it into court on the merits. However, I think it represents how the National Environmental Policy Act and some consumer rights to know acts could be used to promote consideration of animal emotions in the decision-making process. It involved the importation, and some of you may have read about this in many newspapers that covered it and all around the country and the world, really. It involved the importation of 18 African elephants, I think 7 of them were babies, from what at the time was the African nation of Swaziland to 3 US zoos. And in proposing this importation, the zoos were required to obtain the permit from the US Fish and Wildlife Service. But U.S. Fish and Wildlife Service's legal review was constrained in their mind to the Animal Welfare Act. Whether these animals would suffer pain or be injured in the transportation, whether they would be adequately held in confinement here to avoid unnecessary pain and suffering, and whether they would have access to medical treatment. And of course, these 3 zoos, the Dallas Zoo, the Omaha Zoo, and the Sedgwick County Zoo in Wichita, and they could meet all of those requirements. And so the permit was approved. We argued through NEPA and then later through consumer protection laws that both Fish and Wildlife Service and the zoos themselves were obligated to disclose a much broader wealth of information that is out there, that exists today on the meaning of captivity to the lives of animals, not just in the lives of elephants, specifically. And there's a wealth of research, not only on the impact of removing animals from their herd in Africa and the impact left on the social system within the herd that was deprived of those animals, but also on the animals that are going to be held in captivity for the next 15, 20, 30 years of their lives. And there's no doubt that there's a wealth of pretty readily available scientific information on that. But Fish and Wildlife Service didn't see the obligation to consider it or disclose it. Would it make a major difference? Well, potentially, yes. I mean, you could imagine the public response would be much different if Fish and Wildlife Service itself was disclosing what this captivity would mean to these animals for their lives. You can imagine if the zoos were compelled to disclose it to their consumers, what it might mean to people wanting to view these animals. Instead, the zoos turned it on its head and called it a rescue mission, and that these animals would suffer less because of their actions. So in this particular case, we're talking about really being down here in this circle, trying to show that an animal, in this case, has one or more basic capabilities and incorporating that into the public discussion. However, the idea, of course, is to try to go beyond that with the right to ethical considerations, not just using existing science to show, for instance, that elephants are going to live a terrible life in a zoo, but to try to force more human respect for these basic capabilities, maybe changing the way we go about these decision-making processes in the future, maybe incorporating within the U.S. Fish and Wildlife Service or within the U.S. Department of Agriculture more resources for evaluating our impacts on specific species that they're routinely regulating, incorporating more research. We've done this in environmental law to promote our understanding of our human impacts on the environment. Can we create a condition for creating more respect by investing more into understanding elephants' capabilities, for instance, or apes, or going down the line to raccoons and to penguins and all those other animals that eventually could be affected by us. And then hopefully build upon that to develop more procedural and substantive rights. Martha Nussbaum herself pushes really hard for procedural rights like standing, right? That we need to go beyond just being able to incorporate into the deliberation information about our impacts on the well-being of animals, but that we need to give those animals a right to stand up for them, either through standing in court or standing in administrative proceedings. Another idea would be to give animals guardian ad litems, where they are represented in decision-making process, like represented in the agency's permitting, for instance, of the importation of these animals. And of course, pressure leading to appropriate substantive rights would be a huge goal. I mean, I think we all want to see more substantive rights protecting animals beyond pain and suffering. But can we use this to sort of work our way towards more of a motivator, more public acceptance, more public pressure for these type of rights? Ultimately, right, we want to go beyond that. So we're not talking just about specific animals for which we have lots of science and data on, but maybe more of an assumption that all animals have one or more basic capabilities, that all animals could live a meaningful life, and that our default should be to avoid harm until we know more about what it is that our actions can do to prevent or to harm or to promote their lives. And of course, all of us want to be left alone, and I think I put that out there as just a really lofty goal in a perfect world. I mean, in our world of humans, right, we don't want to have our rights infringed upon, any impact on our capabilities without some substantial societal justification. And ultimately, I think one can make the argument for that for animals too. Now I'm running out of time. I want to leave questions. So I'm just going to throw this slide up here with some resources about compassionate conservation, a paper I wrote. Martha has a book coming out on World Animal Day on December 10th of this year. I'm very excited about that. And hopefully she'll be coming to VLS in March to talk about that book. I've been talking to her about that. And then there's a Center for Compassionate Conservationism in Australia that I'm going to give this to. So I went a little bit longer than I intended, but let me stop there and answer any questions that I can.
Great. Thank you so much, Mike. So for our viewers, we do have a few minutes for questions, and we can do at least a few of those before we're out of time, I think. So you can enter any questions that you have in the chat or comment space, and we'll get through as many as we can. Our first question is kind of a long one. What are your thoughts on the incessant harm done to animals in animal testing, including the fact that current law protects this industry and encourages their exploitation? The industry consistently points to strict regulations, which are in reality as flexible as can be, and violations happen all of the time, resulting in at most a slap on the wrist. The industry is allowed and encouraged to be secretive. Not to mention the benefits to humans is minimal, and the consideration of how this work impacts humans in the lab psychologically is basically unaddressed. How are we to address these injustices?
That's a big question. That's a lot of stuff asked there. Let me just say, first of all, to be honest, most of my work focused on wild animals. At Friends of Animals, our focus was on promoting sort of more individualistic concerns about our behaviors affecting wild animals. Friends of Animals itself has done a lot of work over the years on captive animals for research and entertainment purposes as well. I think that you're right that even the Animal Welfare Act, which is quote unquote our strict regulation of captive animals and their well-being, excludes 90% of research animals. And the 10% that are covered, as you said, I mean, pain and suffering is still a day-to-day basis for these animals, particularly because many of them, chimpanzees in particular, have very advanced intellects and emotional and social needs. I think what we would all want, of course, is to see a substantive law that bans these activities. And I think there's some encouragement that is possible. I think we saw chimpanzees, for instance, get more protections in the last few years from research and entertainment industries. But overall, it continues to be neglected. I mean, I would say the right to ethical consideration is intended to help bring to light more of this and to encourage stronger motivators towards protecting them. But short of us getting a bill passed right now, they're exempt, and I think that's a big problem.
Okay, thank you. Next question. The big ag industry, from factory workers to CEOs, don't care about animal physical suffering. Will the argument for animal sentience help shift away from this cruelty, or do we need to push to address physical suffering first?
Well, we have pushed physical suffering first. I think, that has been the focus of animal welfare laws. Now they exclude so many different farm animals. It's unbelievable. But we have focused on it, and we have passed those laws, and we have seen other states, for instance, California, most recently pass state laws designed to tighten the noose around animal suffering in big ag, to include animals that were previously exempt under federal law. So I think those things are important. With regard to increasing motivators to include sentience, to encourage more laws that protect farm animals, do I think it's going to immediately change things? No, I don't think that the US Congress is going to pass a law that recognizes sentience in farm animals. But I do think that it's pretty clear that animal advocates and those pushing those motivators have brought a lot of fear into the industry. And all we can do is, I think, make sure that that fear continues to be increased, and hopefully that more people are brought on board. I mean, look, I think there's a lot of reason to sit here and be very pessimistic, but on the other hand, I had a friend, a colleague, Justin Marceau, who sat at lunch one time with me over a decade ago and said to me, "We're going to be the last generation to eat meat, or our children will be." And I was almost astonished that he would say that. But the more that I thought about it, the more I realized that we talk about the ethics of eating meat, the more we talk about the benefits of not eating meat, the more people are engaged in becoming reductionists or vegetarians or vegans than ever. I mean, in my life, I would have 20 years ago never had those conversations. The key has to be towards continuing to keep a deliberative stance over this and pressure. And we can hope that that changes the way Congress acts. We can hope that makes more states follow what California has done. And ultimately, we can hope that more people just turn away from it.
Thank you. Seems like a good note to end on. And we're out of time. We need to let our students and professors get to their afternoon classes. Thank you again, Mike, for your presentation. And thanks everybody for joining us today. Our final talk will be online this Thursday with Professor Emily Broadley from Harvard Law School. And I hope that you will join us then. See you soon.